All right, well, let's get started. Good evening. My name is Nelson Rosario. I am the president of the Intellectual Property Law Society here at Chicago, Kent. And before I continue, I'm obligated under Illinois law to let you know that we're videotaping this event tonight. So hopefully no one has any problems with that. Okay, good. So tonight's topic is about the Cuban embargo and trademarks. And before I talk about that, I'd like to thank our sponsors that made this possible. Patisol McCullough, the Chicago Intellectual Property Alliance, and the Chicago-Kent Alumni Association. I'd also like to thank the Chicago-Kent Student Bar Association and my executive board, who have been very helpful, and this would not be possible without them. So, as I said, this is about the Cuban embargo and trademarks. And the embargo has been in place in some shape or form for 19,378 days. And it may seem odd that we're having a discussion about something that's been around for over 53 years. But I think that it's actually a rather timely event for a couple of reasons. Little under 2 weeks ago, the United Nations held a vote for the 22nd year in a row, actually, condemning the U.S. embargo against Cuba. And what was interesting about this most recent vote is that this was the lowest support that the United States has ever received for their continuing embargo against Cuba. In fact, it was only the U.S. and Israel that voted to continue the embargo. Additionally, the Castro brothers are not getting any younger. Fidel Castro himself is 89 years old. His brother Raul, who runs the country, is 82. So I think this is a timely event because I think we may actually be approaching the end of the embargo. And you don't necessarily have to believe me, but you can look on the internet for yourself. Such varied organizations as The Economist, Foreign Affairs, Forbes, the Brookings Institute have all written about the growing private economic activity in Cuba and what will happen when the embargo ends. So it's our hope tonight that you learn a little bit about the legal issues related to the embargo, kind of what has happened so far, and then maybe get an idea of what will happen when the embargo actually ends, because that may be sooner than any of us think. So with that, I'm going to turn it over to Professor Buccafusco, and thanks for coming out.
Great, thanks Nelson, and thanks to the whole intellectual property law students group. As always, it is a terrific group, terrifically turned out, always with excellent events, both intellectually and gastronomically stimulating. So before we begin, and before I introduce the panelists, I'd like to take a moment and note the loss this week of one of the brightest stars in Chicago's gastronomic firmament, Chef Charlie Trotter, who passed away surprisingly earlier this week. When I started writing about intellectual property, my first article was on recipes and copyright law, and I decided that the fun thing to do would be to interview a bunch of chefs to talk about copyright law and cooking. And Chef Trotter was the first of those to agree to talk to me. He took me into his kitchen, served me an incredible meal, and said all kinds of awesome things about copyright law, culinary creativity, and the rest. And he's always been an inspiration, I think, for many chefs, for many in Chicago, and we mourn his passing. So a toast to Chef Trotter. He'll be missed. Cheers. But now I'd like to introduce our speakers tonight. I'll be moderating a discussion. The discussion will go on for approximately 45 minutes or so, an hour. Then we'll open it up for questions from the floor, wrapping up probably no later than 7:30. In order from your right to left, our speakers are Judith Grubner, who is a partner at Arnstein and Lehr in Chicago. She received her bachelor's degree from Oberlin College and a law degree from George Washington University. She has an extensive practice in intellectual property law, including copyrights, trademarks, advertising, unfair competition, domain name disputes, you name it, she knows about it, and this is a topic that she's written about and spoken about many times in the past, so we're grateful to have her. To her right is Mariano Municoy, who is currently working for the Latin American IP law firm of Moeller IP Advisors. His law degree is from the Universidad de Buenos Aires. He also has 2 LLM degrees, one from the Universidad de Torquato de Tela in Argentina. You'll notice I don't have terribly good Spanish pronunciation, but this is the trouble when you have a Cuban project, right? We're going to have to do our best. And also an LLM degree here from Chicago, Kent. He practices in wide-ranging fields of intellectual property law and technology policy. And yet to his right is Joseph Schmidt, senior counsel at Shefsky and Froelich, who has been practicing for over 30 years in various intellectual property matters as well. His bachelor's degree is from Loyola University, and he is also an alumnus of Chicago-Kent Law School. Joe was one of the first, if not the first, of the IP strategies teachers here at Chicago-Kent, and taught as an adjunct professor here significantly throughout the first decade of the 21st century. So welcome back, Joe. Very good to have you. Welcome back, Mariano, and welcome, Judith. So many of you may know much about the Cuban embargo. Some of you may know relatively little. So I wanted to start by providing a little bit of background on it to set the stage for us a bit. As you probably know, right, Fidel Castro, wearing his green fatigues, smoking his long cigar with his shaggy beard, right, overthrew the Cuban government of Fulgencio Batista in a revolution in the 1950s, culminating in a kind of victory for Castro's regime in 1959. At this time, Cuba was a thriving economy, primarily due to, increasingly due to, at the time, foreign investment. It's been estimated that at the time of the revolution, 75% of the best arable land in Cuba was owned by foreign nationals or foreign corporations, including and primarily corporations based in the United States. In the summer of 1960, after the revolution had succeeded, Castro's government began a process of nationalizing much of the property and industry in Cuba, including land both owned by Americans and owned by Cuban citizens. Many of the Cuban citizens then living in Cuba decided to flee the country, including those who owned various corporations, especially the ones about which we'll be discussing this evening. And people did very different things once they left, right? So some people, like Alonso Menendez, who was at the time the founder of the Monte Cristo Cigar Company, who was producing cigars very famously in Havana at the time, left for the Canary Islands and began producing his Monte Cristo cigars there, eventually switching his factory to the Dominican Republic. Others, like Jose Arrechabalda, who was the founder of the Havana Club Rum line, moved to the United States and stopped making rum. He took his trademarks with them, but allowed them to lapse in the 1970s. Over the course of this time, right, as all of these people departed, the Cuban government nationalized all of the industries in Cuba, and in so doing took over all of the trademarks, brands, factories, recipes, et cetera, et cetera. In response, the American government was very upset and imposed an embargo, which started at least in the 1958, grew throughout the 1960s, and has been updated ever since. Notably, perhaps you've all heard the story that the night before the embargo went into effect, President Kennedy insisted that his secretary buy him 1,000 Cuban cigars so that he could smoke them throughout the rest of his term. So he stockpiled, I believe they were H. Upmann Epicure cigars, which were his favorite at the time. So he, this is, perfect insider trading, right? Taking advantage of knowledge of what's going to happen to the markets here. So at the time, though, right, at least with the initial embargo, the embargo did not limit the opportunity for Cuban corporations to continue to preserve their trademarks and intellectual property rights in the United States. That has since changed, and Judith is going to give us a little more background on it. She's going to start talking a little bit about the litigation and legislation involving the Havana Club Rum disputes. Very quickly, though, I wanted to mention some of the disputes involving the litigation over cigars. So basically, two things happened that are noteworthy. The first thing that happened is that people like Menendez sued the Cuban regime, sued the importers of the Cuban cigars who had nationalized their corporations and their brands in United States federal court, and succeeded in a series of cases in the 1960s and 70s in recovering those brand names. And thus they were able to continue to produce cigar lines like Punch, Romeo y Julieta, Monte Cristo, Partagas, and others in Dominican factories for the U.S. market. Nonetheless, they were prevented from selling those cigars in foreign markets, Canada, Mexico, Europe, and elsewhere. Right? So in all of those places, we have basically parallel production. Right? In the United States, cigars primarily from the Dominican Republic by former Cuban owners of those marks. In the rest of the world, Cuban-made products by companies that were nationalized in the Revolution. Right, so this is the major distinction. There's at least one situation that's slightly different, though, and this is with the Cohiba line, which is perhaps one of the most famous cigar brands around. This was started as a Cuban brand in 1968. An American company named General Cigar saw that this was going to be popular and realized that Cuba would not be able to sell their cigars in the United States, so they began producing a Cohiba cigar as well. They had significantly different trade dress. They marketed it on incredibly awful cigars at the time. Right? So whereas the Cuban Cohiba was a handmade cigar that retails for many, many dollars, the Dominican versions were machine-rolled white owls. If you've seen white owls at like the gas station, right? Basically, they were white owls with Cohiba stickers on them. So very different products, very different markets. And they didn't intend to sell them, right? They just wanted to kind of claim the brand. So over the course of the 80s and 90s, they litigated significantly back and forth, resulting in a relatively recent Second Circuit Court of Appeals opinion in 2010, which said that General Cigar, despite the fact that it didn't have priority to this mark, despite the fact that it had abandoned the mark for a significant time in the 1980s, and despite the fact that it was taking the brand precisely to tread on the goodwill that had been established by the Cuban Cohiba mark, nonetheless was entitled to use the brand in the United States, and the Cuban brand was not able to continue its registration for the Cuban trademark. So we still now have parallel brands for the Cohiba as well. The Cohiba from the Dominican Republic, which is available in the States, and the Cuban Cohiba available everywhere else in the world. Right, so this is the situation as it stands more or less with cigars, and Judith is going to tell us about how it's gone with rum.
Good evening, everyone. The Cuban embargo finds its source in the 1917 Trading with the Enemy Act, which is 12 U.S.C. Section 95A, gives U.S. presidents the power to impose foreign trade embargoes. In 1963, President Kennedy imposed just such an embargo on Cuba. In July of 1963, the Treasury Department, who was empowered to issue the regulations under this embargo, issued the Cuban Assets Control Regulations, known as CACR, 31 CFR Part 515. These are fairly extensive regulations. They govern all activities that have to do with Cuban nationals, the Cuban government, and the U.S. nationals interacting with those folks. They prohibit most transactions between Americans and Cubans. And also, they prohibit the purchase in other countries of Cuban goods. So those of you who go to Canada to buy your cigars are technically breaking the law.
None of us ever do that.
And I'm sure nobody does that. The regulations have some reasonableness to them. They contain certain exceptions for transactions that concern U.S. intellectual property and Cuban intellectual property. At 31 CFR 515.527, there are the regulations about Cuban nationals owning U.S. trademarks. They're allowed to register and renew transactions and payments involving U.S. patents, trademarks, and copyrights in which the government of Cuba or a Cuban national has an interest. However, like the IRS code, you have the basic section, you have the exception, and you have the exemption to the exception. In this case, in 1998, an exemption from this general exception allowing Cubans to register trademarks in the U.S. became law. No such transaction or payment involving renewal or registration is permitted if it concerns a trademark, a trade name, or a commercial name that was used in connection with a business or assets in Cuba where those business or assets were confiscated, unless the original owner of the mark gives consent. So you've got the basic, don't trade with Cuba, you've got the exception, but it's okay for Cubans to register trademarks, and you've got the exemption, but if those trademarks were originally used by parties in Cuba whose assets were confiscated, you need their permission to register that trademark in the U.S. The regulations are administered by the Treasury Department's Office of Foreign Assets Control, known as OFAC. There are criminal and civil penalties for violating the embargo regulations. You can get up to 10 years in prison. There's up to $1 million in corporate fines and up to $250,000 in individual fines. There are also civil penalties of up to $65,000 per violation. You don't hear very often about people being sent to jail or fined, but those provisions do exist in the regulations. And all records on dealings with Cuba, which are permitted, must be maintained for 5 years. The CACR contains certain general licenses for anyone to engage in particular transactions without applying to OPAC for any kind of authorization. The section allowing the registration of trademarks in the U.S. by Cubans is one such general license. But then you have the exemption concerning the confiscated marks. So if you want to register one of these confiscated marks in the U.S., you have to apply to OFAC, for a specific license, allowing you to do that. Specific licenses often cover travel to Cuba. You may have been there yourself or know family or friends who have gone there. Often these are heavily regulated trips that have special licenses allowing them to go there. A general license exists in the regulations at section 515.5.1.12 for certain legal services. So when you're out there practicing and someone comes to you and wants you to do some work for a Cuban national, there is a general license in the regulations that allows you not only to perform those legal services, but also to get paid for them. But to get paid, you require a special license from OFAC. So no property in which a Cuban government entity or a Cuban national has an interest may be imported to the U.S. This has particular effect on Cuban nationals who are attempting to renew their trademarks in the U.S. for goods produced in Cuba, because they won't be able to provide the required specimen of use. In 1995, the regulations were amended to permit filing, prosecution, and renewal of Cuban trademarks by U.S. nationals, receipt of Cuban trademark registration certificates, prosecution and defense of oppositions and infringement actions, and the payment of fees to the Cuban government and Cuban attorneys for those actions. I first got involved in this area because a number of years ago, one of my prior firm's clients had a Cuban registration that was coming up for renewal, and our paralegal came to me and didn't know what to do because she was aware of the Cuban embargo. She thought that we wouldn't be allowed to pay fees to a Cuban associate to renew this registration, and what were we going to tell the client? So I started poking around in the law, in the regulations, and I found this 1995 exemption. So we didn't have to go to a Canadian associate and have the Canadian associate do the Cuban renewal, which is also illegal, by the way. So what does this all mean in the real world? Well, in the real world, we have the trademark Havana Club, which has been an issue in dispute between Bacardi and Pernod Ricard for over a decade, maybe close to 2 decades at this point, over the rights to the Havana Club trademark for rum. The mark was first created in Cuba, as Chris said, in the 30s by the Arechabala family. And you'll have to ask Mariano to pronounce that properly for you. He says it really beautifully.
I do it in the Argentinian version, so probably it's not Arachabal, but probably.
But it's quite beautiful. Anyway, the best I can do is Arechabala. It's a family. They owned this trademark. They had manufacturing facilities in Cuba. They made really great rum. And Havana Club Rum was known all over the world and in the U.S. For being quite exceptionally good. They registered the mark in the U.S. in 1935, and they sold rum in the U.S. under that mark for at least 20 years. In 1960, the Castro government seized their manufacturing plant and their trademark and began producing Havana Club Rum on their own. The Arechabalas could not renew their U.S. registration because their plant had been confiscated, and unlike the situation with cigars, they didn't go to the Dominican Republic and open a new plant. So they had nothing to produce for a specimen, and the U.S. registration expired. Although they didn't have a channel at that time to produce their famous rum in the U.S., they intended always to resume production and marketing Havana Club Rum once they had the means and the opportunity. In 1976, the Cuban government, under a sort of a sub-agency named Cuba Export, registered the mark Havana Club in the U.S., using an exception that existed at that time for Cuban-affiliated entities to register and renew U.S. trademarks. The French liquor producer, Pernod Ricard, partnered with the Cuban government to sell Havana Club Rum internationally, including in the U.S. Cuba Export transferred the Havana Club trademark to a joint venture consisting of the Cuban government and Pernod Ricard that was called Havana Club Holdings S.A. There's a lot of players. There are no scorecards. I do have an article out on the table where you all checked in that you're welcome to pick up, which also details all of this backing and forthing and has all the parties' names. That entity renewed the U.S. Havana Club registration in 1996, using the same exception for Cuban-affiliated entities that existed at that time. However, in the meantime, Bacardi purchased the trademark rights from the Arechabala family, whatever rights they had, and began selling Havana Club in the U.S. Pernod filed an infringement suit against Bacardi, and Bacardi filed a cancellation proceeding in the Trademark Trial and Appeal Board against Pernod, or the Havana Club Holdings, to try to cancel their Havana Club registration. In 2000, Pernod lost the infringement suit and its subsequent appeals. In 2004, Bacardi lost the cancellation proceeding. So we've got Pernod Ricard not able to enforce its trademark, its registered trademark, against Bacardi, and Bacardi unable to cancel that registered trademark. It was a big mess. That's a term of art. In 2006, Havana Club Holdings ran into trouble trying to renew its registration because the CACR, having been amended, barred it from paying the renewal fee relating to confiscated assets. They didn't have the Arechabala family's consent to the renewal, so they couldn't renew. They weren't too sure whether that 1998 amendment involving confiscated goods actually applied to trademarks. There'd been no rulings up to that point. So they went to OFAC to try to get a specific license to allow them to renew their trademark, to pay the fees without the original owner's consent. Well, they ran into a complete brick wall there. They were told that they couldn't get this license, they couldn't renew their trademark unless they came in with the consent. So they appealed to the U.S. District Court for the District of Columbia, and in 2009, that court granted OFAC's motion for summary judgment, concluding that OFAC had not acted in an arbitrary and capricious manner. Now, this was a review of an administrative agency under that standard. The court also found that OFAC's decision to refuse the license was reasonable because the original owners had not consented. So Pernod appealed to the DC Circuit and argued that the 1998 amendment should not be applied retroactively to renew a previously registered trademark, as that was a violation of their substantive due process rights. In 2011, the appeals court upheld the district court's decision. They said that there was no violation of due process because the CACR also contains a very clear warning that any exception at any time can be amended, modified, or revoked. And so the Pernod Cuba Export organization could not rely on the previous practice of allowing such renewals because the 1998 amendment had revoked that previous practice. No fundamental rights are involved in filing a trademark, so therefore no substantive due process problem. The 1998 amendment was also rationally related to the government's legitimate goal of isolating the communist Cuban government and encouraging a more hasty transition to democracy, which we can see happening all around us right now, right? Cuba Export had notice and opportunity to be heard, so the fact that OFAC does not hold formal hearings also was no problem. And the fact that the original trademark had been confiscated was reason enough to deny the license. So then, Bacardi applied for the Havana Club trademark in 1994 for rum and in 1999 for certain merchandise, clothing, T-shirts, hats, that sort of thing. Bacardi also filed a cancellation petition, again, against the U.S. registration of Havana Club by the Cuban organization. The 2 Bacardi applications for Havana Club have been suspended forever, awaiting the outcome of these, all of these lawsuits. And the cancellation proceeding was also suspended. I checked just before I came over here, and everything is still suspended, even though the lawsuits are over. It says to me that there might be some settlement talks going on behind the scenes, but there are the 2 Bacardi registrations, there's a couple of Cuba export applications. A member of the Arachabala family also has a pending application which is suspended, Gloria Marquez Arachabala, for the mark Rum Havana Club Arachabala. So that's involved in this whole situation. And then there's the Cuba export application. So all of those are just floating around, waiting for some resolution of this entire issue, which so far, according to the Trademark Office, and some of these suspensions were last revisited last month, is still not resolved. There is also a 2002 World Trade Organization decision that, an 85-page decision, that the U.S. is violating the TRIPS agreement by requiring consent for these confiscated marks. There's a few U.S. courts that have also held that the consent provision is unlawful. Congress, usually once a year, revisits this issue to say, oh my, we're under a court order from the World Trade Organization telling us to get rid of this provision requiring consent. We don't think we're going to do that this year. Maybe we'll do it next year. And they so far haven't told the Treasury Department to get rid of this provision. So on top of UN action condemning the U.S. for requiring this consent, we also are under a court order to get rid of it, and nothing seems to be happening there. And that's what I know about the Cuban rum cases.
Good, thanks, Judith. So this is really fascinating stuff. One of the things that I find most fascinating about it is the amount of money that's been spent on it. Right. So if you think about this rum case, right? So how many people here have any associations whatsoever with the brand or the mark Havana Club? So some of you have some, but the number is, it's maybe half of you have some, and this is probably from foreign travel only, right? You've seen it in foreign markets when you've traveled abroad, right? This is a product which has not been on the shelves in the United States for 50-something years, right? It's a rum brand that hasn't been available for 50-something years, and they've spent, clearly hundreds of millions of dollars on both litigation and lobbying efforts over a very old brand that has kind of only mild penetration into the U.S. market, into U.S. consciousness. And it's very easy to create a rum brand, right? There are probably 6 of them out there right now that have all been created in the last 2 years, and they all have like 400-year histories and everything. Like, it's not hard to do. So part of my interest is like, why do you think that this is such a big deal, right? I'm happy for the whole panel to think about this, right? But so, why are these companies, these are otherwise rational companies, right? Pernod Ricard, Bacardi, and others. Why do they seem to be spending, what seem nearly infinite sums of money on brands like Havana Club? Mariano, you have thoughts?
I can give you my international view about this and about what consumers, at least in Latin America, think about Havana Club, the Cuban rum. We love it. It's like that. Bacardi, usually we don't like it that much, but Havana Club is like the best, and everyone is like very, very popular. The emerging countries like in Latin America, Europe, I think maybe Asia, I'm not sure. they're consuming more and more Havana Club Rum and other cigars too. The same Cohiba, a box of Cohiba cigars can cost more than $500. So, and people in Latin America at least, they are consuming these products. So I think these companies are investing money because they need to have these trademarks in order to commercialize these products.
Yeah, what do you think, Joe? Is this going to be worth it for them? Will this end up having been money well spent for whichever company ends up winning here?
Well, I think part of it may come in because of licensing also. I looked at some trademarks.
Oh, okay.
And there's T-shirts, someone else also, not necessarily the Havana Club mark, but it might have been Havana Club because Cohiba's already cigars. Someone had tried to register Havana Club for cigars.
Yeah, I saw that, right.
So, and I think the Cohiba cigars are in 120 countries.
Mm-hmm.
So there could be a big market there. They could carry it even further. And if you look at some of the sales figures for Bacardi and how huge they are, it might be worth it.
Is that right? Yeah, Judith, you agree? There's a chance or is this just like, passions about, the antagonism towards Cuba on the one hand, the antagonism towards, Uncle Sam and the Yankees on the other?
When you first asked the question, I was going to say beats me, but thinking about it in a more rational way, there is tremendous goodwill in these Cuban marks, just enormous goodwill, even though we may be talking about a percentage of the U.S. consumer market of people 60, 70 years old or older who remember the original Havana Club Rum. The idea that you could be the company that brings it back, and then you can go into the wonderful history of it and get all these endorsements and licensing and that sort of thing. I think there's still some value in that. Mattel, which is not Cuban and has nothing to do with rum, nevertheless fights very hard if they have abandoned a mark for more than 20 years and somebody else tries to pick it up.
Really?
They just don't want that happening. They see a fan base out there of people in collectors clubs that if they ever wanted to bring that mark back, they would have ready-made market. And it may be that that's the same thing that's going on with these Cuban marks.
Interesting. Yeah, so one of the other things that I find fascinating, obviously I find lots of stuff fascinating. You're gonna have to just bear with me and my fascination with this topic tonight. It seems like a relatively unusual incidence of national and international politics finding their way into an IP dispute in a pretty direct manner. Direct in some ways, but also hidden in others. So Judith mentioned the changes to the law in 1998 that affected the ability of Cubans to protect rights in trademarks or other intellectual property when it had been confiscated without consent. The way that made it into the law was as a rider to a multi-thousand-page bill known as the Omnibus Consolidated and Emergency Supplemental Appropriations Act, which was added both to the House and Senate versions of that bill and never considered for discussion or debate among either House of Congress, and was signed into law, almost certainly without anybody having any idea what was in it. So how unusual are these kinds of situations, and what should we think about them, right? So should we be especially concerned about American legislators, American politicians, playing politics with our intellectual property laws? Are there other examples of this in other situations that you think might arise?
Well, I think they're clearly doing that here. And the typical way to solve this problem, as we all know, is through the courts. And when they went to court, the case that Judy was mentioning, and taking it through the courts, in '98 that bill was changed, and I think some of the things I read refer to it as the Bacardi bill,
Right.
because it stopped the courts from intervening in these disputes.
I mean, the litigation was on the way at that moment, right? I mean, it was, the Arrechabaldas had signed their rights to Bacardi.
Yes.
It looked like, the other marks were coming up for renewal, right? I mean, this was clearly on the horizon, right?
Yeah, there was definitely enormous lobbying going on in the background. To get, it's fairly easy if you have a large lobbying contingent to sneak things into an omnibus budget bill. It happens all the time. There were, who was president at that time? I don't remember. But there's always been the exiled Cuban community in Florida who are very politically active. And it may have been that at that time there were some intimations of lifting the embargo, and somebody went to Bacardi, who obviously had an interest, a dog in this fight, and said, use your political power and get something into this bill to help us out here.
Right. Yeah, so one of the things that Judith, one aspect, so you heard a lot about a lot of litigation over these marks. There's actually more litigation that wasn't mentioned, right? So one of the ones I find particularly interesting is, so when Bacardi attempted to use the mark in the U.S., Havana Club, they produced a bunch of bottles of Havana Club Rum that said Havana Club Rum made in Puerto Rico, right? And on the back of the bottles it said made in Puerto Rico, and everywhere on them it said made in Puerto Rico, but it said Havana Club. And they were sued at one point by the Pernod Ricard folks under false advertising claims, claiming that the bottles that said Havana Club made in Puerto Rico were falsely advertised and falsely marketed because some number of Americans would be confused as to the source of those bottles, right, where they came from, thinking that either the bottles or the rum came from Cuba instead. The court had no problem with this case. The U.S. wins in all of these things when the U.S. makes the decisions. And despite the fact that there was evidence that 18% of consumers were confused as to the source of these goods, the court didn't consider the survey and looked basically on its own at the bottles and said no reasonable consumers could be confused as to the source of these products. 18% of you are clearly unreasonable, and thus, right, there's no problem here, that these are not misdescriptive. The court did note, however, that although this was making a claim about the false marketing issue, it wasn't making a claim about whether the Havana Club mark itself could potentially be misdescriptive if used in the United States as such, right? If it didn't come from Havana,
Geographic
right,
misdescriptiveness,
it would be
yeah.
geographically misdescriptive as a mark.
And in the trademark office, they're not making people file acquired distinctiveness declarations either, which is an odd thing. Why are all these Havana Club marks going through all this prosecution, some going back to 1994, and the trademark office isn't saying, show us your acquired distinctiveness in this geographical mark or geographically misdescriptive mark.
Right.
If you're not producing these goods in Cuba or in Havana, there's no sign of that in the prosecutions either.
Right. So Joe, what do you think would happen? So if they did try and challenge these marks as geographically misdescriptive when applied to products produced in Puerto Rico or elsewhere, would those be successful, do you think?
I think if produced elsewhere, they should be successful in a geographically descriptive challenge. In one of the registrations, I don't know if you remember, Judy, Havana was disclaimed. I'm not sure if that was in one of the cigar or rum ones.
Will you say a bit what it means
Yeah.
as disclaimed?
When you file a trademark application and there's a merely descriptive term involved in the mark, the trademark office requires that you enter a disclaimer for that term, that you don't claim any exclusive rights in that term apart from how it's used in the mark. So that someone else can come along and also have, use Idaho. You might have an Idaho potato, but somebody else can have Idaho cars or automobiles.
Idaho rum.
Idaho rum, yeah.
Idaho vodka, probably more
Vodka.
likely, but.
Right. I think that there is one of these pending applications where a Section 2F, that's an acquired distinctiveness declaration was filed. But I think it was the T-shirts one. I don't know if the examiners are just rolling over and saying, well, this is famous, and we know it's famous, and we're not going to make you
Yeah,
prove
that
it.
might be, but,
Never happens when I file an application.
I mean, typically, if you had Havana, you would expect that it
You
would
would.
get a
Right.
geographically descriptive.
The court was very interesting here. I mean, I'd like to read to you what the court said. So this is a situation in which the court said this is obvious, right? This is clearly a situation in which reasonable consumers could not be confused, and we're actually pretty upset that you even brought this claim, Pernod Ricard. They said, we hasten to add that cases like the present one should be rare. For one hopes that a case with truly plain language, as the court thought it was, will seldom seem worth the time and expense of contesting in court. That this particular case and related ones have been litigated so intensely is due, it seems, to the unusual political baggage and branding potential involved. The court seemed to know that there was something more going on here than the dispute between these two parties and you know, general issues of trademark law. So I'd like to change a little bit and talk now about some of the issues looking forward towards the future. And first, I'd like Mariano to tell us a little bit about his ideas. But I want to kind of ground this first in some international context, right? So Judith mentioned a couple of things that are significant. One is that the negotiations between the Arrachabalda family and Bacardi on the one hand, but they were also negotiating with the Cuban company at the same time, right? Both of these companies were trying to buy whatever rights they still had, were occurring in 1993. Anyone know why that's significant? 1994 ends up being the TRIPS agreement, right? The Trade-Related Intellectual Property Agreement that is the major international agreement about governing intellectual property disputes, right? Judith also mentioned the dispute at the World Trade Organization, where the European Union, interesting, the European Union, right, not Cuba, sued or challenged the United States' use on the kind of nationality principle that it wasn't treating countries fairly, or at least it wasn't treating Cuba fairly because it was treating them differently than it was other countries in violation of the TRIPS agreement, right? We've had this long-standing now, right? How many years? When was that? This 2002, right? 2002 opinion by the WTO court, right? At the time, the U.S. agreed with the European Union. We'll fix this problem in 12 months, right? 12 months lapses in. We'll do this in 12 more months, in 12 more months, and now we are 12 years later, and still no end in sight.
Well, one of the things I read on that, where the politics comes in again, is Pernod is a French company, and that's probably why, what some people say, why the EU got involved, because it wasn't just Cuba, it was the financial interests of a major company in Europe.
Sure. I wondered, any reason to think that this was more successful because brought by the EU rather than brought by Cuba? Right. So Cuba is a TRIPS signatory. Right. They could have brought this claim if they wanted to. Any reason to think that this was a strategic effort on the part of the various parties to bring the dispute via the EU rather than as Cuba? Mariano, any thoughts?
My thought is that the Cuban government didn't have the expertise or the resources basically to do this, to present this legal action at the WTO. Just for you to have an idea, the Cuban government, yes, they have filed their own trademarks in many countries. I mean, they have protected Cohiba and Havana Club in Latin America and in other countries, but usually they use some, like in the Havana case, they use foreign licenses. So basically, I think the Cuban government didn't have the expertise. Like right now, we can see Brazil, they have a huge expertise, but you can see smaller Latin American countries that they don't go to the WTO,
Right.
although they don't have any big problem like this one. So I think that's the main reason.
Good. So why don't you kind of start us off now looking at the future? What can we expect if and when the embargo ends? Where do you see things going?
Well, basically, what I want to make clear is that in Latin America, at least, is it legal? I mean, the owners of the Cohiba brand is the Cuban government. So basically, the Dominican Republic company who sells Cohiba here in the U.S., they cannot sell it in Latin America. So basically, I guess That means that the market, well, probably is equal if you compare the whole Latin America and the US is maybe equal in terms of dollars. But going into the future, what I see, what I think it will happen is basically that once the embargo is lifted, there will be many US companies filing trademarks in Cuba. And I would like to know how many of you think that it's true that there are some estimations that say that 5,000 trademarks owned by Americans are registered in Cuba. How many of you think that is true? 5,000.
Exactly.
Only 3, 4 people. Around 5,000. Okay. Only 3 or 4 people. Okay, that's the estimation, but that's it's possible. It's possible. U.S. companies have been filing trademarks in Cuba. We are not sure if the number is 5,000. I did some research at the WTO, the statistics that the WIPO published, and you can find that the number of trademark applications in Cuba, the highest number was of trademarks applications in Cuba was in the year, let me see, in the year 99, 4,200 trademarks filed in Cuba. Most of them, of course, are filed by foreign companies, non-residents, because Cuban people usually they don't file trademark applications. So that number, that was the highest number, has been going down since 99, and I think 99 was maybe a year where tourism and the international economy was some peak, Spanish especially, hotels, chains of hotels, and Germans and Italians, they were all going to Cuba for holidays. Cuba was like a boom, I think, at that time, and basically I think these were mainly European companies filing trademarks in Cuba. Since then, the number of trademark filing in Cuba has been going down, and if you compare how many trademarks are filed these days in Cuba, it's around 2,000 trademarks are filed in Cuba, most of them around 80 or 90% by non-residents or by foreigners. So if you compare 2,000 trademarks filed in Cuba, you compare that number with the number of trademarks filed, let's say, in Costa Rica, which is around 10,000, we are saying that the number of trademarks filed in Cuba is around 20% of the number of Costa Rica. So what I think is that the number of trademarks filed in Cuba is very low these days. For the future, I think it should be at least equal to countries like Costa Rica or maybe others. And something very important and very peculiar about Cuba. Cuba is one of the few countries who adopted the Madrid Protocol in Latin America. As probably many of you know, most Latin American countries are civil law jurisdictions. They are based on the first to file system. So filing a trademark application is very important. And most of the countries there were not members of the Madrid Protocol, only Cuba and Antigua and Bermuda. Last year, Colombia joined, this year, Mexico. So if we consider that Cuba already has the Madrid Protocol in place, and these companies have been filing trademarks, but not as many as in other countries, I think in the future, when the embargo is ended, US companies especially are going to file more in Cuba. And I think there is one basic problem, right? If US companies are going to file in Cuba, which is a problem? And even today, there is an embargo. They cannot commercialize their products. In Cuba, there is it's possible to file a cancellation action for non-use, lack of use, like in many other countries. So if a trademark owner doesn't use a trademark for 3 years, in Cuba, a third party can file a cancellation action. Well, this has happened, and Kraft Foods has had a case like this. One of the trademarks was canceled by the Cuban PTO, and basically a court in Havana, they decided that this cancellation was not due because they applied the theory of the act of God, basically meaning that the trademark owner didn't have the capability or the ability to use the trademark because of embargo. So I think long term, once embargo is ended, we will see many US companies filing trademarks in Cuba.
So your point about the cancellations is one that the WTO disputes, I think, raises, right? So as we've said, right, the WTO has decided that the U.S. is in violation of the TRIPS agreement, They've been in violation of the TRIPS agreement now for over a decade. And one of the remedies for violation of the TRIPS agreement, if it is not subject to compensation, is some type of like trade retaliation. It's one of the cool things about the WTO. It's like you get like eye for an eye kind of responses, right? So should we be worried then that if this is going to continue for a while, right, that Cuba, the EU, or others will retaliate by canceling U.S. marks? Right? Will we see them cancel the mark for Levi's, the mark for Coke? Right? So now there will be Cuban versions of all of those things. And I guess the suit was brought by the EU, right? Even the EU could do this, right? The EU could decide to cancel the marks for Levi's and Coke if they wanted to there. My guess is that's not going to happen, right? But do we have to worry about Cuba doing something similar?
No, I don't think so, because basically Cuba, they don't have, Cuba is not a member in the dispute, but I think they probably don't have the capability. And also, I think they are cautious. Like if you compare, Brazil had the chance to retaliate a few years ago against the US, and they didn't, because they consider, they probably, they make the political statement that they could retaliate Brazil, which is the most powerful Latin American country, and they didn't retaliate against the US. So I think Cuba probably won't do it, but with the current Cuban government, I think, nobody can say that it's impossible.
Yeah. Judy, do you have thoughts on this?
My thoughts are that if there is substantial retaliation, they're going to harm any ability to lift the sanctions,
right,
lift the embargo. So, as Mariano said, I think they're being very cautious about that. If they attack major U.S. companies and their trademarks, there goes the lobbying again.
Right, yeah.
The political situation is not going to improve.
Sure. And certainly it seems like there's at least some kind of political détente between the European powers and the American presidents. This would be my guess, right, that the American presidents have basically said, look, we can't say anything bad about, we can't say anything good about Cuba because we need to win election in Florida. And so as long as that's the case, that it's going to be very hard for the American presidents to say otherwise.
And it's funny that you mentioned that, because at least in Latin America, being in favor of Cuba in many countries is a political gain.
Right.
Like last year in Mexico, Cohiba for cigars was recognized as a well-known trademark. In Mexico, there is this procedure where trademark owners can request the Mexican trademark office to declare that a trademark is well-known. When the INPI in Mexico did that, they declared that Cohiba was well-known. They made a big event. So ambassadors were there, people from Cuba were there. The same this year, just 2 months ago in Chile, in API, the Chilean trademark office, they gave the Chilean government they use it a different way. Not a trademark. They choose to protect habanos for cigars as a appellation of origin in Chile, and they did it, and they had a big event with the press there, because in some Latin Americas, for some Latin American people in some Latin American countries, it's a political game.
Great. So Joe, where else do you think we're going? What does the future hold?
Well, I'm going to focus a little more on LOL, which is lots of litigation when the embargo ends.
This is good. This is what our students need to hear. This
hopefully
means jobs.
Hopefully some of you will be lucky enough to get involved in some of it.
How's your Spanish?
What do I think is going to happen when the embargo is lifted? The country probably hasn't thought too much about it now, but we're going to have to think about setting in place some trade issues, including trademark rights, and not just lift the embargo. Clearly normal trade going back and forth, how that will go. Whether they address the trademark rights is a different issue. One of the things, if the government tries to address the trademark rights, is I think they have to be mindful of our trademark statute and who we're trying to take care of. So what can they do if they pass special laws on Cuban trademarks, and then how would that relate to the trademark statute that we already have now? So I don't think that's the right approach. And as a lawyer and as a litigator, my preference would be to let the courts decide this, because we already have a trademark law here. And I think it's a much better approach because I'm going to run through some of these situations. There's some very different and competing interests, and I don't think you could pass a law and be fair to all the people involved, which is a problem with general legislation like that. A couple of different parties you have to think about. One is the Cuban government, assuming that they come forth and give up on owning the companies. I don't know, or they may keep the companies there. I can't answer that. They also have partners like Pernod, legitimate, good company, trying to do business. You have the original owners, but that's a real problem now. There's a lot of German artwork in the paper lately, the last couple of days, and it's like, how are you going to find the owner of that piece of art from 1938? It's the same thing here. We're now over 50 years, and where are the owners and what rights might they have? Some might have some rights. Some, as we've heard already, have sold those rights. And then you have U.S. companies that under the trademark law, maybe some of them acted in bad faith, something to be determined. Some of them may have acted in good faith, thinking, I can get rights to this. When you look at just a couple of the parties, there's two we've talked about is Havana Club and Cohiba, and there's a third one that I find to be most famous from what I've been reading is the Cubita coffee. So if you take Havana Club, Bacardi got involved in it. But if you go back to Bacardi, they were actually Cuban in the first place, and it was a family business. And they left Cuba with the revolution and moved to Puerto Rico. So maybe there's some claim by them that they may have some aura of Cuba in them so they can do this. Although I do not believe they were selling the Havana Club at that time. There's also a case in Spain involving Bacardi and Pernod, and I wonder if there's the case in the U.S. and a case in Spain, because, help me, Mariano, Archibala?
Yeah,
Archibala moved to Spain. So it's kind of funny that there's a case in the U.S. and a case in Spain, is maybe they have Bacardi has a little more interest in Spain because now there's someone living there. The Havana Club registration that the Cuba entity owned was registered in 1976. Bacardi didn't file until 1994, long time after 1976. And Bacardi at this stage of the game is, from what my understanding, is only selling in Florida, in the U.S. And one might think that maybe they're limited to Florida because they're trying to control their potential exposure right now in case they lost these cases, which, as Judy said, still aren't finished. And Cuba sells Havana Club in 120 countries. So there's not much competition going on anywhere right now. Maybe we're waiting for the legal fallout to see what happens. That's a very different case, and those are only just some of the facts that might be considered. It's a very different case than Cohiba cigars, because Cohiba never registered its mark in the U.S., which is very different than what Havana Club did. And Cohiba, what I understand, has not been around forever like Havana Club has, or 70 years or 100 years. Cohiba was made especially, different than Monte Cristo, Cohiba was made, my understanding, especially for Castro. And in the beginning, only Castro could have it. It was his cigar, so it was only Castro and who he gave it to. And it was around maybe in 1981 that Cohiba started going into other markets, right, much later. And of course, now it's very famous. So then General Cigar came along, U.S. company, and started selling Cohiba cigars. Those are the ones, I think you mentioned, Chris, they're made in Dominican Republic. And from what I can see, they're probably only sold in the U.S. is my guess.
That's
and
right.
they're not competing with in the 120 other countries.
Yep.
So never having registered Cohiba in the U.S., and they could not have sold, a Cuban company could not have sold Cohiba in the U.S., if you think about it, because if it was made for Castro around the time of the revolution, they couldn't sell here. So they have no use here. And then you have Cubita coffee. It's the best-selling coffee in Cuba. It's only sold in Florida right now by a company called Universal Brands, and they've been selling it there since the 1990s. And they have a registration for Cubita. So if you go to Cohiba Cigars, they're going to come in here. What are they going to do? They never had any registration rights, but you don't need registration rights. They could invoke a famous mark theory here in the U.S., except the question is, was the mark famous before General Cigar started selling Cohiba? These are the type of issues I don't think you can get involved in legislation, and I think someone's going to get hurt if you try and legislate all of these matters that normally would come up in a trademark case. The Cohiba could also take an approach, the Cuban Cohiba, that their mark is being diluted. But again, you're running up against the same roadblock that you have with a famous mark, is in order for your mark to be diluted, it has to be famous before the junior party started to use it. And I don't know if that's true. And I don't know if our legislature knows that that's true, and I don't know if they'd bother to look at it. So again, somebody who might have rights may lose those rights if you try and just broadly registrate giving all rights back to Cuban entities that maybe they never had those rights in the United States in the first place. Maybe they had them in Cuba, maybe they had them in some other country, maybe not in the United States. That's what our courts are here to resolve. Havana Club, that's interesting. As Judy mentioned, the registration for Havana Club is not canceled yet. It's prior to when Bacardi started selling. It's prior to when Bacardi started using it. So who has rights to Havana Club? I don't know. I don't have enough facts. But I think that's where the litigation has to come in, and maybe one party will fall or take a license. I would assume some of these people will avoid litigation and try and settle. And you were mentioning, Chris, why are you going to put in so much money to fight for this? Well, right now it wasn't that much of a fight in a way. It was a lot of money, but you were probably going to win. The Cubita coffee, I for one have never heard of that. I don't know, has anyone here heard of Cubita coffee? One maybe, two? So I don't think they're going to succeed on being a famous mark for dilution or a world famous mark. And so what happens to Cubita coffee when they want to come here, when someone in the US has already registered the mark here and is using the mark here, and Cubita has not used the mark here? So from that perspective, what I see is there's two possibilities, legislation or litigation, and I think legislation, from my limited review of all this, would be very unfair to both sides, not giving them their day in court to resolve this.
Great. So this is really helpful, really thoughtful. And I want to save a bit of time for questions. A couple of things about the future and markets are perhaps worth pointing out. So at least in the cigar realm, there are two main companies that own these disputed marks. One of them is General Cigar, which owns Cohiba, which it's litigated over, and it also owns marks like Punch and Partagas as well. And the other one is Altadis, which owns the Dominican marks for Monte Cristo and Romeo y Julieta. Altadis also, however, owns 50% of Habanos S.A., the Cuban tobacco company. Right? So when the embargo ultimately ends, they're in a position to exploit these marks wherever they want to. Right? So I think they saw the writing on the wall, and they bought half of the Cuban cigar market. Right? They're half of, so they're in a good position here. This is a different case with respect to General's marks in things like Partagas and Punch, however. One thing that certainly interests me is what's going to happen to the markets for these products, right? Assuming that they get in here, what will, the tobacco in Cuba is grown in an incredibly small area of the island, right? When there's demand for these products, once they're available in the United States, how will that affect the demand? How will that affect the supply? How will that affect the price and the quality? Right? All of these things strike me as deeply uncertain and worth thinking about. But I would like to save some time for some questions from the audience. Anybody have questions? If you do, please raise your hand and speak up loudly so that we can all hear you. Yes, sir, Mr. Mariano. Yeah, thoughts? Judy, you haven't given us your prognostications yet.
My crystal ball's kind of cloudy.
It's the rum.
The rum, right? Which I'm looking forward to having after this talk. I kind of agree with Joe that the political solution is not going to work. Even if the embargo is lifted, our good legislators are just not going to think of all the issues that are going to arise in situations like Bacardi and Pernod. And one of the things I was thinking about while I was listening to Joe, what about res judicata and collateral estoppel in these cases? They've litigated these issues already. Of course, it was under a statutory regime we're postulating here. There'll be a change in the law, so then if there's a change in the law, do they get to go back into court for second, third, fourth, fifth bite at the apple? Who knows?
Right.
I mean, I'm sure that'll be the first motion in any case that's brought.
So Mariano, the two litigators on the panel are skeptical of legislation. Perhaps we're not surprised. Are you any more sanguine about the possibilities of some kind of legislative response that might solve these problems?
I can approach this question just from an international point of view. And for instance, what comes to my mind is the solution that was and is the compromise that was achieved to resolve disputes between trademarks and geographical indications at TRIPS. We in Latin America have already enacted laws protecting geographical indications, and many times, like Havana Club could be one, many times there is a conflict between geographical indications and trademarks that already exist. Most of these laws in Latin America, they are leaving up to the parties to settle and to negotiate and to find a solution. We are seeing also in many countries in Latin America the use of mediation. So I think maybe the parties, if they sit on a table and they can make the numbers, they can find an agreement.
It's interesting we didn't really talk about geographic indications, but there's certainly a similarity here between these kinds of disputes. And for example, the disputes between Anheuser-Busch's Budweiser and the Czech Budweiser Budvar. You're all welcome back next year for the panel on that. Other questions? Yes, sir.
Is this embargo, is this only going to be lifted by like an executive action? And if that's the case, do you think we're going to have a better time frame here with the president who's not going to have to run for re-election and won't have to run to Florida? And if that does happen, is the legislator going to have, is Congress going to have to act immediately to solve problems like that? Or would it just be horrible if they didn't?
Well, my understanding is it's up to Cuba, not up to the U.S. to end the embargo. As long as those companies are still nationalized, the U.S. isn't going to recognize it.
Right. So for your first question, the The embargo is now an aspect of congressional legislation, which stipulates what it has to take to be repealed. And I believe it requires legislation to be repealed now. Right? So it can't merely be the act of the, so originally it was an executive order, right? The president could revoke it whenever he or she wanted to. Right now it's a matter of legislation. I believe it requires legislation to repeal. You know, so at least relatively recently, Obama has said that you know, the embargo will stand as long as the Cuban people are not free. You know, interpret that how you like. I think that was during his second term too, where he at least did not have the shadow of a looming election.
Yeah, but there are Democratic congressmen and senators who need to be reelected.
Right, there are, and yeah. So it's yeah, look, my cloudy, my crystal ball is no better than anyone else's. My sense is that nothing happens so long as there are Castros leading Cuba, right? So you know, I think, you know, whatever that's about, whether politically, emotionally, internationally, my sense is that, you know, as long as there is a Castro leading Cuba, the embargo will exist.
He hasn't changed yet, so why should he?
Right.
And probably when you see some IPOs in Cuba and the national companies are now publicly owned, then the embargo is going to end.
A question in the back.
Both Castros being rather far along in years, is it going to take a non-communist regime in place to lift the embargo, or is it just the next one in line, or what's going to happen politically in Cuba for this to occur?
Yeah, I mean, I guess again, we're all speculating. Mariano, do you have thoughts about this as someone from outside the American political system?
Not that, no.
No.
Honestly, it's a very, I think, complex matter, politically, emotionally, from all point of view. But what I think is that many things are changing in Cuba. I was there like 15 years ago as a tourist. I met people, and it's, I think the problem is between the government. Last year, there was a record of Americans visiting Cuba. I think almost 100,000 Americans visited Cuba, and it's just getting easier and easier for you guys to visit Cuba. When you go there and you see that Cuban people are just like anybody else, and it's the system is different, but they are also trying to pushing to change the system little by little as much as they can. So I think that there won't be a communist government after Castro. That's what my thought, my I wouldn't say wish, but I think most governments, at least in Latin America, they are meeting in the center politically. And I think this is a very big discussion that it will require hours to analyze politics in Latin America, which is very, very complex, and it's possible to do it with rum and cigars.
Yeah. Unfortunately, we did not have hours, but we do have an opportunity to go out and have some drinks and some food. But before we do, please join me in thanking our panelists for a wonderful discussion. So please join us outside. Thank you very much.